Now, a Deputy Speaker of Parliament can vote while presiding and be counted as part of a quorum for decision-making. This remains the law in Ghana. The Supreme Court today ruled that it has not been convinced to depart from this position it took on March 9th. Private legal practitioner Justice Abdullahi, who filed the matter, headed back to the Supreme Court insisting the judges got it all wrong.
Right, it makes sense now.
Are you surprised by the outcome of the decision?
Obviously not. Prior to today, I had made it clear that a review application is probably one of the most difficult things to succeed in at the Supreme Court. And so I knew the odds were against me. Indeed, some had predicted 1:100. I had predicted almost 0. Except that I still moved forward with this because, in principle, as I said, I believe that the Supreme Court is made of seasoned lawyers, and if you make strong arguments before them, they were amenable to reviewing their decisions, their previous decisions. As it turns out, they decided otherwise. And once they've decided otherwise, I think we have to move on as a nation. What I didn't want was a situation where posterity would question us.
Now, let's listen to Deputy AG on the development in court today.
I mean, are you satisfied with the outcome of the decision first?
Definitely satisfied, because it has been our position always that the review application filed by Justice Abdullah is unmeritorious and clearly an abuse of the process of the court. So yes, I am satisfied with the ruling of this honorable court.
I mean, from the process that he filed, I mean, do you think that had he marshaled those arguments in the initial matter, that could have perhaps, I mean, because the review window certainly is a smaller window?
Definitely. So as you heard the honorable court hold, the review application is very strict and the grounds clearly stated, and one needs to find his case within the threshold set for a review application, that exceptional circumstances which has occasioned a grave miscarriage of justice, and there are new information that has been discovered which was not present at the time of the determination. I do not think, even without going through the review application, any argument advanced by the plaintiff on the basis that the court ought to have had regard to previous constitutions and other statutes of the Commonwealth will still have held. As you clearly heard, our constitution, which is a written one, is sui generis and ought to be interpreted in accordance with its peculiar nature. And so reference to other constitutions, even previous constitution, is no basis for interpreting the constitution